Today, we'll be discussing perhaps the most important Supreme Court case when it comes to gun laws in the United States, District of Columbia v. Heller. Hello and welcome to Talks on Law. I'm Joel Cohen. Today, we're joined remotely by a constitutional scholar and a gun rights expert, Professor Joseph Blocher of Duke Law School. Welcome back to Talks on Law.
Thanks so much for having me on, Joel. I appreciate it.
And Professor, I guess we should get on the record. You weren't just a spectator when it comes to District of Columbia v. Heller.
As a very, very junior associate attorney at the law firm of O'Melveny and Myers in Washington, D.C., I helped represent the district in that case, co-authoring the merits briefs. The oral argument was done by my unfortunately belated but brilliant and wonderful colleague, Walter Dellinger.
So what was at stake here in the Heller decision?
That's a great question. I mean, I think that the critical thing about Heller is that the court was presented for the first time really with what had been for decades the sort of central debate in Second Amendment scholarship and law, which was, does the Second Amendment extend beyond what people think of as the sort of organized militia and encompass what people often call the individual right, that is a sort of private right of individuals disconnected from militia service to have a gun, for example, at home for purposes like self-defense.
When you say militia, maybe we need to go back to the actual wording of the Second Amendment. How is the militia phrase built in?
Yeah, it's built in the first clause of the Second Amendment. The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, many people, when they read that, sort of see a natural break between the first and the second clauses. So people who think that the Second Amendment is about the sort of organized militia, maybe roughly the equivalent of what we today would think of as the National Guard, tend to focus on that first clause, that is a well-regulated militia being necessary to the security of a free state. And their basic argument is, and this was the argument that prevailed in the courts for 200 years, is that the Second Amendment was ratified to protect the state militias from disarmament. Now that sounds maybe anachronistic to us today, but we have to remember back in 1791 when the Second Amendment was ratified, there was really great fear about this newly constituted federal government, which had massive powers compared to what came before. It had a federal standing army. A lot of people thought that was a threat of tyranny, and so preserving the state militias, it's kind of like a structural federalism provision, if you like. So that's one view. That's the one that focuses on the first part. People who support the sort of private right, individual rights reading tend to focus on the second part of the Second Amendment, which says the right of the people to keep and bear arms shall not be infringed. And their argument is, well, even if the organized militia were the sort of reason for the amendment being ratified, the right itself extends beyond that. And it covers, there's lots of ways to think about this, but it covers either what you might call the general militia, which is basically everybody who could be called up for militia service, not just those who are actively serving, or it just extends to all of the people referred to in that second clause. And the right itself, again, goes beyond militia-related activities and includes things like armed self-defense. So in a nutshell, there's lots of variations, but in a nutshell, that's kind of the two competing visions of the Second Amendment and how they map onto the text.
So, Professor, which one is right?
Well, I can answer which one is right doctrinally. The way that the court decided the case was to adopt the private purposes, individual rights reading of the Second Amendment. And again, that was the central question. The court split 5-4 on it, but in his majority opinion, Justice Scalia adopted the individual rights view. And that was important because it was really the first time that the Supreme Court, and really with one exception, kind of the first time that any federal court had adopted that reading, despite the fact that the Second Amendment had been on the books for, at that point, almost 220 years. So if I was putting this on an exam, the right answer would be an individual private purposes right. Now, many people, including many historians, still contest that. They say the court misread the historical evidence, but at least as a matter of law, that's the answer now.
Well, Heller had this magnified, huge impact. It was actually about a specific law in particular. Maybe we can drill down a bit. What was going on in D.C., and was the D.C. law unique in some ways?
Yeah, it's a great point because a lot of constitutional cases that we sort of think of as foundational today start with laws that are in some respects kind of outliers, and that was true in District of Columbia versus Heller. So the case started because a guy named Dick Heller, actually along with some other plaintiffs, most of whom dropped out along the way, wanted to have a handgun at home for self-defense in the District of Columbia. And at the time, the district had a law which basically, with a few exceptions that didn't cover him, made that impossible. You were not allowed to have a handgun at home. You could have long guns like shotguns and rifles with some restrictions, and guns had to be kept locked or disassembled when not in use, like a safe storage provision. So Dick Heller argued that that violated his Second Amendment rights. And what Dick Heller said was this violates my right to keep and bear arms because it's not just about militias, it's about self-defense, which is what I care about. Now you asked, was the district's law an outlier? And the answer to that is yes. At least by the time this case was argued in 2008, I can only think of one other city that had a handgun prohibition like DC's, and that was Chicago. And actually the Supreme Court would come back 2 years later and strike down Chicago's law. That was a case called McDonald. So yes, we start with these sort of, very close to the ground facts. Dick Heller, who happened to be a security guard at the Federal Judicial Center in Washington, wants to have a handgun at home for self-defense. What we get is this enormous law-changing decision from the Supreme Court.
Professor, am I right in interpreting Heller as granting the right to keep rather than keep and bear as it's described in the Second Amendment?
I think that's actually a pretty fair way to put it. I mean, again, what Dick Heller wanted was just a right to have the handgun at home for purposes of self-defense. And because that's what he asked for, that's all the court technically had to rule. And so he won. He got that right. Now, that doesn't mean it's limited just to within the home, but that was all he asked for, and that's all the court had to resolve. Now, a lot of people argued as soon as Heller came down, well, logically, if the right is a right to have a gun on hand for self-defense, then it has to logically extend outside the home because the need to engage in the armed self-defense could occur outside the home. But it's kind of technically at its most narrow, Heller can be understood, I think, as a case about keeping. That is the right to keep a handgun in the home for purposes like self-defense.
Let's talk about some exceptions that came out of the Heller decision. Scalia's majority opinion listed a number of important exceptions.
This is a crucial point, and it's actually one that gets overlooked a lot. And the simple, straightforward answer is Heller absolutely recognizes the legitimacy of some forms of gun regulation. And again, I just think that's so important to emphasize, as people sometimes people who celebrate the opinion, as well as people who criticize it, sometimes read it as if it's like a grant of some absolute unregulable constitutional right. And that's not what the majority says. Justice Scalia's majority opinion is really clear on this, that the right to keep and bear arms, like all other constitutional rights, is subject to various forms of regulation. And actually, a very famous passage, famous for those of us in the field anyway, starting at page 626 of the opinion, he says, "Nothing in our opinion should be taken to cast doubt on such longstanding prohibitions as," and I could go on, but laws against possession by people convicted of felonies, people with mental illness, possession of dangerous and unusual weapons, weapons in sensitive places like schools and government buildings, concealed carry, restrictions on commercial sale of arms. The court just lists these as, suggests that they are longstanding prohibitions and suggests that they're constitutional. They're often referred to as the sort of Heller exceptions or the Heller carve-outs. And that passage, that really just kind of one paragraph plus a footnote, really became the centerpiece of post-Heller litigation. Like, what else fits in there? Heller says felons. Well, what about a person who's convicted of a domestic violence misdemeanor? Or does that count as a felon? Or what about a nonviolent felon? Does that fall into it? So that's where a lot of the law went right after Heller. But it was all with the recognition that this right, like all rights, is subject to regulation. And the reason I think that's important is because you'll often hear people say, I oppose the Second Amendment because I support gun regulation, or I support the Second Amendment and therefore I oppose gun regulation. And that's just a false choice. Like, you can recognize an individual right to keep and bear arms and the legitimacy of gun regulation. And that's what Heller does.
How about the dissent? It was a 5-4 opinion, as you mentioned. What was the main takeaway from the 4 justices in in the dissent or dissents?
It's an interesting question because there's really two dissents, but it's the same four. So the first dissent was authored by Justice Stevens. And what Justice Stevens did is interesting. He basically adopted the same methodology as Justice Scalia. That is, he took the originalist approach of looking to historical materials to understand the meaning of the Second Amendment. And he came to a different conclusion. I mean, based on some of the same exact sources even, he concluded that the Second Amendment was, as the lower courts had held for most of American history, about organized militias, not about a private right to have arms for self-defense. So he took issue with the sort of majority's basic holding about the sort of private purposes right. And again, he was joined by three others. Justice Breyer also wrote a dissent, which took a kind of different approach. And what Justice Breyer did was say, okay, I'll assume that there is some kind of individual right to keep and bear arms for private purposes, including self-defense. But it's got to be subject to regulation, as the majority says. And, Justice Breyer says, this law should be constitutional even if there is an individual right to keep and bear arms, because the elected officials of D.C. back in the 1970s looked at this. They thought this law is justified as a way to, keep down gun homicides and so on. And we, the justices of the Supreme Court, should mostly be deferring to those kinds of policy judgments. So he would have recognized the right, but still upheld the law. Justice Stevens would have said, no, the right is really just about militias.
I hope you won't bite my head off for the simplicity of the question, but is Heller still good law?
Well, that's a hard question. To paraphrase from The Simpsons, I would say short answer, yes with an if, long answer, no with a but. The yes with an if is in the court's most recent major Second Amendment decision, which is Bruen. The majority and the dissents and the concurrences all pitch themselves as being compliant with Heller. They all say, we are just doing Heller. The majority in Bruen says, we're just extending Heller outside the home, that was a case about keep, this is a case about bear. It kind of extends logically. The concurrences, most notably Justice Kavanaugh, joined by the Chief Justice, cut and paste that language from Heller about what kinds of regulations are still permissible. So they, again, pointing back to Heller. But the reason I say if, or maybe no with a but, is that the majority, authored by Justice Thomas, notably does not reproduce the nothing in our opinion should be taken to cast doubt on such long-standing prohibitions language from Heller. So there's a little bit in the air about just how much of the Heller exceptions survive after Bruen, or if we have to do it in a different way, a different methodology. I mean, if you take Justice Kavanaugh and Chief Justice Roberts, that concurrence, those two were necessary to make the majority in Bruen, and they say that the Heller exceptions are still good law. So some lower courts, I think, are still reading it that way, but that's exactly where we are right now, and more to come.
Joseph Blocher is a professor of law at Duke Law School and the co-director of the Duke Center for Firearms Law. Joseph, it is always a pleasure. So nice talking to you today.
Thanks so much, Joel.